First of all, I want to welcome you to the panel of our International Economic Fund, which I entitled for myself, Russia Will Pay. It's not about that it should pay, it's about the way that it will pay. And honestly speaking, for me, it's a kind of a manifesto for now rather than an evidence-based statement. That is to say, I don't have any guarantees to rely on that Russia will pay. But when preparing for today's panel, we were much in communication both with our international experts and Ukrainian ones. The more we communicated, the more I came to convince myself, not even at the level of ideas and notions, but at the level of facts, that the aggressor will pay. And this country will pay not only in money, but also in the way, like it is the verdict that the Hague court has just rendered on MH17 crash. So this panel is about the fact that justice is a really powerful tool of preserving peace, of ensuring peace, because lack of justice, the lack of accountability, was one of the reasons, just because the Russia wasn't punished for the previous crimes and offenses, that it was not responsible for the first and the second Chechen military campaign. It was not responsible for Georgia, Syria, for the Crimea and Donbass. So this was not one of the speediest cases. I mean, on MH17, it took 8 years to administer justice, but sometimes justice doesn't work in the ways that we imagine it to. And to a great extent, that's exactly why this war has happened. They attempted and they weren't punished. They attempted again and they were not punished again. So the matter of justice is not only about retribution. All of us are from businesses, and for us, retribution is not a philosophical, but a very speedy, very tangible, specific point. But the first front is the global front. It's the front line of justice and accountability. From the outset of the war, I was much in communication with my former colleagues in Russia, and they were confident that they wouldn't be punished, even at the highest level. That is to say, the people that worked and continue working with the government, the Kremlin, etc. And naturally, they are the incarnation of the philosophy of the senior leadership. They were sure they wouldn't be punished. They were sure that somehow they would make arrangements. And from my perspective, it's a huge cause, grave cause for them to be punished and for justice to be administered. On the one hand, the purpose of our panel is to give a nudge and a boost to the Ukrainian business to start preparing and start moving this along this pathway, to start going to the courts and press their own rights. On the other hand, it's very important for us today to speak about this roadmap and the route of this march, because it's a very complicated and a complex story indeed. Nobody has all of the answers to the questions. And I'm very much hopeful that today our experts will help us at least to provide the answers to a portion of these questions. On the other hand, a huge purpose of this panel is to make at least a small contribution towards the reformation of the global justice system, because justice has to be functional not only in terms of punishment and retribution of the crimes already committed, but also on preventing crime in the future, and that's a huge purpose. Of course, it's not the first and the last discussion of the kind. Two important events have already happened. It's the first one I have already mentioned. It's tribunal on MH17 aircraft crash, and the next question is law enforcement. How will the court decision be enforced? So the question is, how will these people be brought to liability? So the same goes for liability. So if we win different suits against Russia, so what's next? They will not be willing to pay. The next thing is the resolution rendered by the General Assembly of the UN on Monday, on the 14th of November. It's a huge picture of the Ukrainian team, and today one of the members of this team, Kliuchkovskyi is going to be with us. It's the first decision of the UN General Assembly that we at least hope will have tangible, specific outcomes. This resolution, amongst other things, says that Russia has to pay for all of the damage caused to Ukraine in this war. And today we'll be talking about what that means. But the world is moving along very slowly but surely. The system of global justice is at work. Previously, they said for justice to come, the mist or the fog of war has to be allayed. And in the concept of wars, which is the concept of the 19th century, it says that during the war, everything is hazy. So doing justice during war is impossible because nobody sees, nobody understands everything fully, so the war has to be over. Some investigative actions have to be taken, and then things will begin to unroll. Now we are living in a digital era, so we have surveillance cameras, satellite imagery, etc. All of that creates such a fantastic database of evidence that the mist of war, in the sense that used to be perceived some 100 or 80 years ago, is non-existent anymore. And we as the Ukrainian society, as the Ukrainian businesses, a legal system, we believe that we mustn't sit on our hands and wait for the fog or mist of war to be allayed, but to pursue justice now. And we know that there is already a string of convictions rendered to military offenders, I mean, for the servicemen, military officers. But from the standpoint of economic crimes, we can also move ahead. So let me introduce our panelists, and let me tell you that today we will be working very quickly because there are 6 of us on this panel, 3 offline and 3 online. In the first place, let me introduce Timur Bondaryev, who is not just someone who deals with these matters legally, but as far as I understand, because he is a lawyer and a managing partner at Arzinger law company, they are one of the key accumulators of expertise concerning how to bring justice to Russian to account. Let me introduce Bernard-Henri, the French philosopher, writer, and a huge friend of Ukraine. Somebody who has been shedding a lot of light on this war. And since 2014, he has been keeping a keen eye on all of the events unrolling and unfolding in Ukraine. Let me also introduce Markiyan Kliuchkovskyi, a member of the working group on reparations. It's a very long name of this working group, and I'm not going to quote it. He's in New York at the moment, and he keeps working on making sure that the resolution issued by the UN General Assembly does not stay just on paper, but transforms into huge changes for Ukrainian people and businesses. Next is Natalia Shapoval, Vice President for Policy Research and head of KC Institute at the KIEF School of Economics. So she knows how to appraise and evaluate losses. Andres Aslund, who is right now in the United States, also a big friend of Ukraine, an economist of Swedish and American descent, someone who knows very well how the United States of America view the issue of reparations as the biggest holder of Russian assets, because you know that the biggest assets of the Russian Federation have been frozen by the United States, and for Svitlana Romanova, Chief Legal Officer, Metinvest Holding representative. She knows it well enough what losses of war mean, because she's been actively working on making sure that Russia will pay. All right. At that, let me start with Mr. Bernard, who is not in Kyiv, but in Ukraine anyway, and I would like to ask Mr. Bernard, concerning the 8 years. Can we have Mr. Bernard on the screen, please? So the 8 years that the Hague Tribunal has taken in order to adjudicate this case on MH17, and the speed of administering justice and the whole global justice system, its speed, the way that it operates. Don't you think it's been too slow? Do you think that the system of global justice is delivering on its mission, prevention of new crimes and offenses, and keeping peace and humanism, thwarting, averting such huge tragedies like this war in Ukraine? The floor is yours.
Of course, it has been too slow. Since the beginning of the 20th century, the principle of the international justice is that it is slow. That's why your initiative, dear Natalia Yemchenko, that's why the initiative of Ukraine has such an importance. For the first time in the history of international justice, you might invent, you might propose to the rest of the world the concept of an instant justice. Documented, of course, but quick. When you look back, all the genocides which happened in the 20th century, it was not only slow, it was so slow that it came too late. Rwanda, it came so late. Cambodia, we had a few weeks ago one of the last trials of one of the worst executioners. He was 85 years old. The survivors were themselves dead sometimes, and the trial came. Sarajevo, most of the criminals died in their beds or in court while they were appearing in court. And I'm not even speaking of the Holocaust. Thanks to some Nazi hunters, some of them have appeared on trials till recently, but after the Nuremberg trials, there was such a slow process. And I don't even speak of Holodomor and of the Armenian genocide. There was no comparison, no real trials. We don't know the names, and they were not punished, and they did not pay of those criminals. So if really you succeed, you Ukrainians today, to provide a fair, honest, documented, but quick justice, it will be a revolution, not only here in this country, but for the rest of the world. All the philosophy, the classical philosophy, has lived on an idea that we had to wait for the ashes to be cold before giving justice. Famous sentence of a very famous philosopher of the 19th century, Hegel, who said that it is at the end of the day, when the darkness comes, when the day is finished, that the bird of philosophy and the bird of justice can begin to fly and can begin to appear. You are opposing to this idea of the all of darkness, of the all of twilight. You in Ukraine, with this idea of instant justice, you are opposing a completely different pattern, which is not the all of the twilight, but the deer of the dawn. The deer, you know, this beautiful animal who wakes up at the dawn, at the beginning of the day, who comes in the battlefield and who intervenes at the moment where the ashes are still warm. To come when the ashes are warm, to come when the memory of the dead is still here, to come when the survivors need justice. If you can do that, and if we, your allies and your friends, can help you to do that, it will be really a Copernican revolution in the very concept of international justice.
Thank you very much. We discussed with you in the very beginning that there are three main principles. Ми обговорювали з тобою.
We have discussed it with you that there are three main principles based on which there has to be created a new justice system, that this system has to be speedy, it has to be documented or recorded. That is to say, it needs to contain evidence and it needs to be personalized. That this is not justice where everyone is against everyone, all versus all, but there is very clear understanding of who committed evil, who committed wrong, and this personalization of criminals is absolutely critical for new crimes never to be committed. How much does this fact of documenting and recording history coincide with the speed of administering justice? Can these two things be brought together, be married together, do you think?
The challenge, documentation and speed, because the cliché, the commonplace is to say that in order to have a proper documentation, you have to take a long time. So I believe the opposite. I believe that it is in the very moment that you can gather the documentation. When you let time pass, the documentation vanishes. The witnesses forget. The survivors die. But it is an admitted commonplace that the more time you take, the more documented you will be. I think that we have, dear Natalia, we have to prove by practice the opposite, that not only speed and documentation can be combined, but they can reinforce each other. Second point, you are right. This question of personalization is crucial because the real trap in these matters of international justice is the trap of generality. One criminal, one and single at the summit, and the others just obeying, just applying the orders. You had, after the Second World War, a very important and famous book of the great philosopher Hannah Arendt about the trial of Eichmann. What was the idea of what was the idea at this time? On one side, you had Eichmann saying there was only one criminal or a gang of criminals around Hitler. And on the other side, you had a lot of people like me, Eichmann, who were not guilty, who just applied the law. And Hannah Arendt wrote a whole book to say, no, the criminal act is a system. It is an organic system. And you have Hitler, you have the gang, but you have also a capillarity. You have also a sort of a spreading of guiltiness which goes to the bottom of the society. Hannah Arendt was right. If we really want to pay justice to the victims, we have to consider each of them as an individual. The victims are not a mass. They are not a package. Each of the victims has a name, has a date of death, some precise circumstances, and it is one of the tasks of the justice, by the way, to give back to them this individuality. The criminals want to mix them in a sort of general darkness as a sort of collective group. We have to give them back their individuality. But the counterpart of that is that we have to give their individuality also to the criminals. One victim, one criminal. One victim, one executioner. I am witness of that since so many years and decades. And here in Ukraine, even in the place where I physically am at this minute, I know that there will be no justice if for each victim we are not able to design, of course, the architect of the crime. In this case, it is Vladimir Putin and the gang of bureaucrats, generals around him. But in each case, in each criminal act, there is one face, one name, one commander who gave the order, one man who applied the order. If we are not able to do this task, to have as many, at the end of the process, as many faces, names of criminals as faces and names of innocent victims, justice will have failed. And this, Natalia, is your task and the task of the Ukrainian people at this moment.
Thank you very much. So I just would like to summarize. Justice could be faster, and actually it's something we really not only could but should change. Justice should be based, evidence-based. Тобто правосуддя має бути все одно.
Justice has to be quick, but it also has to be fact-based. It has to be factual. It has to have names on behalf of the victims and on behalf of the people who commit the crimes. Thank you so much. Thank you for kicking off the discussion. I would also like to tell you that we also were supposed to have Alexandra Matvichuk today with us, who's a Ukrainian lawyer. She recently received the Nobel Prize of Peace. But we decided that I'll just quote an abstract of her work to just back off Bernard's words. She said the following during a meeting with Mr. Emmanuel Macron a couple of weeks ago: peace in our part of the world is impossible without justice. Justice is a guarantee of peace. Russians have committed crimes in Chechnya, war crimes in Moldova, Syria, Mali, Libya, and other countries. For decades, they've evaded punishment. They believe that they can do anything. So we need immediate tribunal, and we need immediate justice, instant justice, across all domains. And if from the viewpoint of justice in regards to real people, that's the business of lawyers. In business, things are slightly different. First and foremost, we understand that it is a huge amount of work that lies on our shoulders. They're not really human rights organizations within business. That's something business has to do. We also have a few routes to take. Legal system is very complicated, and it's not really clear what to do because we don't really have successful cases right now. And the third element of it is that the system is changing rapidly. Not only we're learning, but the system is also learning as well. I would like to ask Timur Bondaryev, a lawyer and a managing partner from Arzinger, to answer three questions. What are the routes we can take? What are the most efficient? So which routes we should take? And what are the main obstacles that you perceive right now? So where is the bottlenecks that we might encounter? 5-7 minutes. Thank you so much, Natalia. Well, Bernard raised a very, very important issue, that the system does not work. And we all saw that when February 24th happened. And so therefore there are two news. There is good news and bad news. Bad news is that the system doesn't work. Good news is that changes are happening. We all know very well how World War I ended, by establishment of League of Nations, and it didn't work. Why didn't it work? What was the goal of the League of Nations? To prevent future wars. That didn't happen. Never again principle did not work. As we know, the World War II happened. League of Nations failed. After World War II, UN was established. On February 24th, we saw that, unfortunately, UN does not work. Even though this week a very important event took place, Markiyan will comment on that later, which is really cool, and I don't want to take Markiyan's money right now, so I'm not going to comment on that. So changes are happening, but unfortunately the system does not work. A very good testament to that is the famous Yukos case against Russia. The price of the case was $50 billion, and it was proven by all courts, but the decision was not enacted. So the shareholders of Yukos have a check where Russia has to pay $50 billion, but it hasn't paid over the last 10 years. But the good news are that the system is changing. And we can currently see a lot of changes. What took place this week in the UN is a really cool event. It's very difficult to underestimate. The decision on the MH117 is a very important case as well, so justice happens. And I'm convinced, like everyone else, that these events will be mentioned in the public international law books. So this is very serious. What capabilities do we have right now? What opportunities we have? We have quite a few. There are 3 that we're working on with our clients. So it depends on the type of clients, of course. But there are instruments of international law. There's International Human Rights Court. Ukrainian courts have also opened their jurisdiction for court cases against Russia because there was a specific decision on of the Ukrainian highest court in regards to removing immunity from Russia, because prior there was this issue of immunity. It was this obstacle. But now it looks like currently this obstacle has been removed, and we will be able to see a lot of interesting court cases, a lot of interesting aspects. There are a lot of private issues we can talk about. There are a lot of those that we cannot talk about. For example, our firm takes pride in the fact that we are participating in this case against Prigozhin and against the Wagner private military campaign. We are very happy that we are one of the architects of this court case, and we are convinced that there is huge potential in this case. And I'd like to once again say that my lawyers and I are very creative. We have things to do, and we're making a lot of progress. But I would like to also highlight the 3 other avenues that are available for almost every claimant: International Human Rights Court, International Arbitrage, and Ukrainian courts. So the International Human Rights Court is the cheapest option. There are no payments you have to make to the court itself, but you have to pay your lawyers. The only thing is that the International Human Rights Court has claimed that they are only responsible for the events that took place prior to September 16th. So if something happened on September 15th, you only have 4 months to make a claim. Also, there are a whole bunch of procedural aspects. We have submitted a few dozen claims to the International European Human Rights Court, but the court hasn't made any decisions on any of the claims we have submitted. And Svitlana also has submitted multiple claims. So we are waiting for the European Human Rights Court to respond, but this is the opportunities that everybody has, so you can make a claim right now. Ukrainian courts, there are no real issues. You can make claims. The worst element for the claimants is the issue of the court fee, which is quite significant. It's 800,000 hryvnia. It could be 800,000 hryvnia, depending on what we're talking about. At the same time, I'm also very skeptical in regards to how reliable the Ukrainian court case decision would be in the future in terms of holding Russia liable. But it is a good instrument to prove losses, because people are moving, documents are being lost, so it's a good way to document something. And the third instrument that we believe to be the best, which has both the expertise and the reputation, is the international arbitrage. Unfortunately, not everyone can use this instrument because there has to be a respective agreement signed, there has to be a foreign investment. Of course, the jurisdiction issue is most important here, and the most important drawback of this instrument is the price, because the fee of the international arbitrage is significant, because we as lawyers make a lot of money, and can you imagine how much our American colleagues make? So it is very pricey, but the good news here is that only international arbitrage has the expertise and the knowledge to evaluate losses and to make decisions on those losses. Because it was the UCAS case that I mentioned, the decision of the international human rights law was $2 billion, and the international arbitrage made the decision of $50 billion. So it's more effective instrument. It takes longer, but so these are the three instruments that we can use right now, that anyone, any possible claimant can use. Of course, the issue of enforcement is very interesting here. But we are convinced that what we are hearing from our foreign colleagues, we are constantly keeping in touch with our American colleagues, British colleagues, we can see that the world is changing and that the criminals will be held liable. Therefore, each and every one of you can choose the instrument that is suitable for you. But we do not recommend our clients to focus on collecting evidence and evaluating evidence right now, because at this stage, every court case that you will participate in, so every claim you will make, doesn't matter whether that's European Court of Human Rights, national courts, the better your evidence base is, the better the decision will be. So we see the competition of case files in regards to criminal cases, evaluation, which Natalia will talk about more. So we're talking about reputable institutions that collect evidence here. We're not talking about certain individuals. We're talking about economic school experts, people who know what economic analysis is, people who know how to evaluate damages. These files, these evidence files will work very well. Or if foreign courts will open their jurisdictions for Ukrainian claimants, that would also work perfectly. I can see that my time is running out. I would just like to say that these three steps are canonical in a way. Evaluation, documentation, courts, and enforcement, nothing new. So we're not looking for new mechanisms. The logic is the same. So the issue is practice, if I understand you correctly. Thank you so much. I'm extremely happy that this panel is taking place today. After this horrible Monday, and after the historical decision of the UN Assembly, as the UN Assembly said that Russia has to pay for what has been done, and it's, like Timur said, removes immunity from sovereign assets. I would like to have Markiyan join us. Could you please bring Markiyan on the screen? I would like to express my personal respect and gratitude to Markiyan. So I have two questions to you. What does this General Assembly resolution give us practically? And what is the position of the state from business standpoint? How does this General Assembly decision impact what business has to do? Is there any difference for the country in general and for the business in particular? Thank you so much, dear colleagues. Thank you for inviting me to participate in this event. The resolution of the General Assembly made on Monday has a very simple impact on Ukraine. It is moving from something more abstract to something more specific. Before Monday, we all spoke about reparations, about our need for reparations, but we never had a clear understanding of how we would reach those reparations, how we would build a system in a way that enables us to encompass everything and anything, to make sure that all claimants can utilize those systems, all those who suffered from the Russian war. Timur and all of our colleagues, we have analyzed different ways of achieving these reparations, but we have came to a conclusion that on the scale of the entire country, none of those work. We looked at Crimean cases that started in 2014, that somewhere under certain conditions we can create suitable circumstances where people can make claims to the international arbitrage against Russia and have positive decisions made. But since then, like with the May 17 case, there has been more than 8 years and none of the decisions have been implemented. And it's not because Ukrainian claimants are doing something wrong, but because there's no enforcement. So none of the court rulings have been enacted. No. There hasn't been a single court ruling enacted. Neither Naftogaz nor Bank, none of the large claimants have received any compensations. Like Timur said, this is very expensive and a lengthy process, so no one has received Russian money yet. So these companies are just like Yukos in this situation. So when we are working in our working group under the leadership of Andriy, when we were drafting the suggestions to present to the president later, we spoke about the fact that we have to establish a new structure, a new compensation mechanism that would work for Ukraine. We want to create this mechanism not simply on a whim, but because we need this mechanism. There's no way around it. In normal civilized life, this mechanism would be created by UN Security Council, like it happened in 1991. After Iraq invaded Kuwait, there was a special commission established by the UN, which was very successful. And this year, its mandate ended, having paid 52 billion to the victims of the war. It is clear that the Security Council would never do this for us because Russia vetoes the decisions of the Security Council, like they vetoed the MH17 tribunal decision. But both us and our partner countries had to have this legitimacy mandate that the global community had to give us. And there's no better way to receive that legitimacy mandate than through the UN General Assembly. That's why we called on for this extraordinary meeting. We introduced our resolution draft and we received overwhelming support from 94 countries of the world. This resolution is very simple. It only has 4 paragraphs. But there are 2 main conclusions from the resolution. The first conclusion, and it's very clearly stated there, Russia has to be held liable for the aggression against Ukraine, including by paying full reparations to Ukraine for all the damages, for all the losses. The second element of the resolution is that UN member states, including Ukraine, have to work on establishing this mechanism which would enforce this liability. On Monday, the General Assembly gave all of us this mandate of legitimacy, so we're moving down towards something more specific, towards the establishment of this mechanism, efficient mechanism, operational mechanism. And we're hoping that the result of this mechanism will be the repayment of reparations to all of the people who suffered from the war, individuals, companies, the state, everyone. So the question is regarding the time frame. So we're talking about the damages after February 24th. So damages that were caused since 2014 are a different story. I wouldn't say that necessarily. The work of this extraordinary meeting of the General Assembly of the UN, which was called on after the beginning of the full-scale invasion, helps us to analyze the aftermath. So all of the resolutions that were adopted in regards to the aggression and the humanitarian situation, and the October resolution on the territorial integrity of Ukraine, all of these resolutions are addressing the aftermath of the full-scale invasions that started on February 24th, of course. In this way, we were forced to structure our next step based on what has been done already, but the mandate of the compensation mechanism will be defined in negotiations, in multilateral negotiations with other allies, whenever that mechanism will be established. It is possible that we might try to include the events in Crimea and the east of Ukraine since 2014 into this mechanism. The practical circumstances were quite different. The legal status was different in terms of how UN reacted to the situation, so it might not be easy. And I am not ready to tell you how or what it will look like, but our main focal point here, I'm going to be honest here, our main focal point was to create a mechanism that would enable us to compensate the most significant damages, the most significant losses and human suffering that took place after February 24th.
Thank you very much. Thank you for your work. Thank you for this intervention. I will still get back to you, but only in the Q&A session. Today we have said that the first step is documenting and evaluating, and we have heard different numbers from the World Bank. We know that the partner of the World Bank is KSC in Ukraine, but how much are the figures that the World Bank has announced as total or aggregated numbers? How much do they cover the real damage sustained by Metinvest, Shapoval, and the other companies? So this is my first question, and the second question is, what is the most efficient way for businesses to evaluate their losses and damage inflicted so that arbitration, the human rights, European Court, etc., will definitely dispense justice? So thank you very much. From day one, we began to count all of the losses. We wrote to the government. We found the people in the government. Yulia Sviridenko wrote it in her Facebook account that we have to count all of the losses, and the office of the president, and in essence, all of the ministries, line ministries have been dealing with that, and all of the 17 organizations that are working on that together with us on that. So our company aggregates all of this data, works on the methodology, and then releases different reports so that there is one figure, but not a lot of mismatches, depending on who issues such reports. As of September, not as of now, it's $127 billion. This is the direct damage inflicted on the infrastructure. Next, it will have to do with the roads, housing stock, etc. So this is the cost to replace certain physical assets. Here, there are not such things that Natalia has referred to. There are 412 businesses that we know quite well in terms of their facilities, and we can talk about in detail. This methodology, this analytical methodology that this figure is based on, comes from the World Bank, and it's about 30 years old, and it's called Speedy Evaluation for Disaster cases. There's also an indicator for economic losses. It's a very technical indicator that does not take on board all of the losses that businesses sustain. And overall, it just considers the state-owned infrastructure. In June, for example, this number issued by the World Bank was 96 billion. Then they counted recovery, the need for recovery, so 350 billion was the number. It's a really conservative figure. And it's not 100% fact that Ukraine will have to be recovered back based on this strategy. Most likely another methodology, another strategy will be taken on board, but this, once again, it's very approximate. And I agree with everything that Mr. Markiyan and Timur and Natalia have had to say. Next, evaluations by businesses have to be made more individualized. There is, of course, a place for an aggregated methodology that Markiyan and Irina Mudra will get everything together, and on average, they will have an assessment of the damages for businesses and will start repaying them. But most likely, businesses will have to work individually, especially big businesses. Scenarios may vary. The methodology will heavily depend on the operator of this funding and liquidity. For the Russian Federation, the central bank is based in different countries, like the 40 billion in the United States, 30 billion in Germany, and they have their own subtle points concerning legislation. But still, there are some things that will definitely be necessary. First, you will have to record things concerning your property. Second, you will have to prove that this damage is there and it was inflicted due to war. So this can be done with pictures, having the date, different documents, etc. And thirdly, how much that costs. And here we have to consider how much the operational activities of the businesses suffered, how much was earned, how many additional losses were caused, and how much it will take in order to restore both the infrastructure and the employees, the labor force, and of course the opportunities lost. For example, a business may have been sold and an opportunity for that was lost. or there may have been mergers that once again were missed. So it seems to me that for the compensation to be speedier, right now you have to start collecting all of this evidence and say, well, this is not a very accurate number, but at least our business amounts to 2 billion, and this is why. So you can make a preliminary evaluation, make a claim on that, and can keep working on that. Yes, I think that you do have to start working on that, because Irina Mudra or Markiyan, they will be adding figures in further meetings, making claims of the Ukrainian business. So it will not just be a technical 350 billion, but the realistic outlay of the business sustained. You have also referred to Alexandra Matvichuk, saying that there are people, and this is the first category that has to be recompensed. And our government and the office of the president, they present all of these figures, and all of this is very eagerly awaited. So today we say 350, but in a couple of years we may come up with another figure. But the people will be saying, but you said 350, and the serious people from the World Bank referred to this number. So let me say that the methodology is more or less unclear, and time is on our hands. And if we get back to Bernard's thesis that recording has to be now while everything is living and breathing, because the witnesses are still alive, things haven't been dismantled yet. And the faster this documentation takes place in evaluation along with that, the sooner these numbers will be added to the governmental communication and legal procedure. Yes, it's very correct. One of the ways of evaluation that we are applying right now are photographs taken with drones. And it's much better than Maxar satellite imagery, because their accuracy is much higher. You cannot just take pictures, especially saying that this is confirmation for something that happened sometime in the past. Thank you very much. So we have spoken about enforcement. It's all about money. And we understand this case that 1991 that Markiyan made reference to is pretty ideal. If you don't know, there was a special mechanism established when compensation was done not with the help of frozen assets, but throughout 30 years, part of the earnings on the sales of oil was paid as a reparation. This was an ongoing mechanism, and this is something that we are viewing. And one of my questions is to Mr. Andres Aslund. If the United States are thinking of making sure that a certain mechanism will come into play, similar to that way. But my question is, the U.S. has frozen some up to $300 billion of Russian assets. Is the United States ready, especially now after the issuance of the UN General Assembly resolution? Is it ready to consider the possibility to readdress this money towards the operations in Ukraine? I understand it's too early to speak about that, but still, what is the philosophy? What is the approach? What should Ukraine undertake in this respect in order to nudge, perhaps, and expedite the due decision if it's not possible to be taken now?
Thank you very much for your and thank you for today. I'm greatly honored with this excellent company. And I'm sorry that I cannot attend in person in Kyiv. I was well asked 2 months ago in September. And you have discussed here many things that are very, very important. But most important, I would say, are 2 things: urgency and financing. And you brought up here financing. So there is only one source of big Russian money available in the West that can be seized. And that's the central bank reserves of the Russian central bank. And as you mentioned, it's about $300 billion that has been frozen in the West. According to the Central Bank of Russia, the balance sheet from the 1st of January this year, it's in 7 different countries, and only 39 billion in the US. I cannot get confirmation about this money from any of the governments. It should be most of it in Germany, more than 90 billion. Second, in France, 60 billion. And then a bit in the US, Japan, the United Kingdom, Canada, and Austria, in 7 different countries, according to the Central Bank of Russia balance sheet. First of all, we should get full confirmation from all countries that they really have this money. They have declared that they have frozen the money, but they have not established that they really have the money. It might have disappeared in one way or the other, not being properly frozen. And this money should be confiscated. Only Canada has adopted such a law, but they have not implemented it as yet. I would hope that the US would do it next, and it would then come from the Congress. There are 2 senators, Republican Jim Risch and Democrat Sheldon Whitehouse, who are considering this. This is what needs to go ahead. The central bank reserves have many great advantages. First of all, it's really state-owned. So it's not a question of the private property right. Secondly, it's clearly defined and we should know where it is, or the government should. Thirdly, it's a lot of money. And fourthly, it's really liquid. To take it, the US has 3 laws according to which it could be confiscated if it were considered to be used for terrorist financing, as one could argue. That, but it would be better to adopt a new law to do so. Let me at the same time warn about oligarch money and others. We got a good presentation here by Timur, how difficult it is to get money, that no money has been paid out from the very clear Crimean arbitration cases 8 years later. The oligarchs will be worse. First of all, it's little money. Altogether, something like $30 billion around the world has been frozen. And it's unclear to what extent various oligarchs are really guilty. It's private money, and that means that all kinds of constitutional rules on private property come in the way. It's elusive. It can easily be moved to another company or to a relative. And the oligarchs will fight like hell in court with the best lawyers you can buy for money. So you will get no money for years. The only reason to go after it is really revenge. It's politics rather than finance. And let me compliment Markiyan on the excellent UN General Assembly decision. I think this is exactly what needs to be done to get a practical mechanism. And this seems to me to be what is needed. And finally, why is speed so important? Inflation today in Ukraine in October is 26.6%. Why is it so high? Because Ukraine does not get sufficient financing from the West. It needs more than $1 billion more a month in order to keep a very low budget going. And therefore, the money has to come forward. And in the meantime, it's vital that Ukraine gets the US to continue paying $1.5 billion a month, as it does very properly, and to get the EU to pay 1.5 billion euro dollars a month steadily. And this should be done for next year, that both the US and the European Union funds that, so that money can flow from January. Otherwise, Ukraine will have a serious inflationary crisis that must be avoided. And whatever happens with the central bank reserves, it will take some time before the money can come into action. Thank you very much.
Thank you very much. Sound was a little bit, like pixeled, unfortunately, at the very end, but I would like to summarize. So first of all, at least state assets, money of central bank, should be confiscated all over the world. Second, Canada has already adopted the law, which allow us to do that. We do not know the mechanism, but the law is already on place. US next. The biggest holder of Russian money is Germany. А я перепрошую, переключусь на українську.
Now, I beg your pardon, I switched to English. So our great purpose is to make sure that Germans also adapt these provisions. And as far as I can understand, this is the a huge incremental purpose that we are pursuing, a seminal one. And it's vital that this money starts flowing into Ukraine now, because economy-wise, this money is not just needed, it's vitally needed. Thank you very much, Andres. I very much hope that the American Senate will approve this law this year. At least we very much hope so. I will revert to you during the Q&A session, and I would like to give the floor to Svitlana Romanova. So, Svitlana, my question is, what is business doing in fact? Because in theory, it's all clear, but what's happening in practice? In practice, business is working. And it's keeping its steel-like front standing. Of course, I can proclaim mottos and slogans, but we can also speak realistically. And realistically speaking, businesses have to continue working no matter what, because our survival, both personal and country-wise, depends on how businesses operate. And businesses will operate as long as they can, as they're capable of. And businesses are doing everything to the best of their ability. But for that, businesses need to apply additional efforts in the conditions of nowadays. And these efforts, once again, to arrange a dialogue with the government, and on the other hand, to meet its own needs, their own needs, and to document and record all of the damages and losses that we have already alluded to. Yes, this damage is really numerous, is a lot. Very few of us used to know about Azovstal prior to this year, but Azovstal is an enterprise, there's a huge history behind it. It's about 100 years old legacy. And it's true, one of the Metinvest assets which is virtually destroyed, razed to the ground. Not only Azovstal as a production facility, 21 industrial manufacturing facilities have also been damaged. The majority of them are based in Mariupol. It's a couple of large manufacturing enterprises, and our enterprise is the huge chemical and coke producing manufacturing facility, and it's already very near the line of hostilities, starting not only with this year, but the year 2014. So as a company that has already been through the first wave of relocation and evacuation from Donetsk, for me personally, this is the second wave or batch of war. There's nothing much to be proud of, but this is still my experience, practice, and we as Metinvest, I can proudly tell you, we entered this war better prepared than other companies.
We came better prepared because we encountered 2014. We had our losses on Donbas. We had damage estimate experience. So we started this process amongst one of the first companies because we were ready for it. We had algorithm in place, so we started the process of documenting damages back in March. So as of October 1st, we had documented completely our damages in Mariupol. And besides just words, I can back it up with facts. I'm not sitting here with papers for nothing. Approximately 300 people were working on documenting damages. 300, think about it. Full documentation consists of 1,500 acts. When I talk about acts, you think about a piece of paper with 2 signatures. No, it's 124,000 pages. 124,000 pages. Processed, developed, drafted manually. Almost 4,000 images and videos. And I'm gonna tell you, as a lawyer, UAVs don't always work. Using drones in Mariupol was nonsensical, and from my standpoint as a lawyer, I think Timur will back me up. Footage and image has to have geolocations and data time group. Otherwise, you don't really know where it was filmed and how it was filmed. So in order to add this as materials to the cases, we need to have all of this documented. Moreover, it is very important to work on collecting information from all sources. We have a bank with more than 150 articles regarding our assets, regarding our plants. As of today, we have processed more than 6,000 buildings and 3,000 mobile assets. So what do I mean when I say 6,000 facilities? It's very difficult to process one facility. Can you imagine how difficult it is to process 6,000? I'm going to tell you a little bit more. So 6,000 facilities are very difficult to process when you cannot access those facilities, when you don't have statutory documents for those buildings, or not all of them are documented properly. So where did those 300 Spartans came from? What did those 300 people do? Right, 300 people sounds like a lot, but those were 300 people who were constantly working on documenting damages. As a result, we made 19 claims to the International Human Rights Court, according to our assets, based on our damages that we suffered. SKM Businesses, SKM Group has made more claims. I'm just talking about our company. We have 60 criminal proceedings on the violations of the rules of war. Having collected all this data, we're working on evaluating damages. A little bit more about evaluating damages. There is a methodology, Ukrainian methodology in place. But, you know, it's like a voice in the desert. We're out here saying that this methodology is not really have an answer. How do we document the damages if we cannot access that? So how do I document damages in Mariupol if I cannot enter Mariupol? We have an answer, actually. We're doing that. And I hope that our practice will become exemplary. But the second issue, the methodology doesn't answer, is how do we evaluate the group of assets? I'm really proud of not being a lawyer. I'm honestly not proud of being a lawyer at all. I'm proud of working for the steel industry. That's awesome. A steel plant is awesome. 10 square kilometers is the territory of Ilich plant. So we're not talking about a tiny facility. We're talking about the entire systems of assets. And evaluating damages there is something completely different. To summarize, I want to say, for people who know me know that I always have something to say, so I know when to cut myself short as well. So to summarize, all of us here are talking about the extreme importance of speed. Right? It's like driving a vehicle. If you want to drive a vehicle, you have to do something. If you want your vehicle to go faster, you have to do something. The vehicle will not just change speeds on its own. And the second thing, do it now or never. I want to reiterate what other speakers said. If we're talking about real convictions, about our real will to have those damages compensated, we have to do it now. We're building this base right now. We're talking about mechanisms, future. We cannot build this house without the baseline. Or if the baseline is uneven, the house will not be built properly. It's very simple. We have to plan what type of house we're willing to build. We have to plan what type of mechanisms we'll use in the process. Yes, we have to work comprehensively along different axes, lines of effort. But when planning the construction, we have to remember that there has to be a very strong base at the bottom, and nobody else except for us can build that base. So as a business, and I'm convinced that all of my colleagues present here, like Inna Hovic from Novopochta right here, I believe that all of my colleagues are working on documenting damages right now because it is a guarantee for a good future that we're talking about. Thank you so much. Thank you. If I understand everything correctly, we can't really speed things up, but if we don't try to speed them up, nothing will happen, right? The people who know me will probably forgive me. Who likes quick sex? If you want to have a quality product, you have to work hard for it. It's not going to happen quickly. It's not going to happen in an instant, and we understand that. And previous speakers have been saying that there have been claims made to the European court, but the responses of the court haven't happened quickly either. We are sitting here waiting, so I would like to extend my respect to Markiyan for making that move. I believe it is a great signal for other institutions as well. Thank you so much. We have time for 3 questions. If the people in the room have any questions, please grab a mic, introduce yourself, and tell us who you have a question to. Do you have any questions in the room, in the audience? Please. Ms. Svitlana, good afternoon. So my first question is, what is the approximate estimate for damages in Mariupol, in particular, and Metinvest in general? I have the overall number, so I'm convinced that there are less lawyers in the audience than economists. So the balance damages, the balance 96 billion. Oh, so the balance value is 96 billion hryvnia. So what is the balance value? It's what I had in the balance, right? So without all of the fun things, a lot of the fun add-ons. And that's what we were able to restore documentally, because having no access to the documents of the company, having documents burned or hidden under the rubble after the bombing. So 96.5 billion hryvnia, which is the balance price of assets that is documented as damaged or destroyed right now. We spoke about the need for separation, for separating assets from the other assets, for separating the assets that have been stolen from the assets that have been destroyed, from the assets that have been looted or lost on the way somewhere. We have to separate all of those categories. So you can just say that, look, all of this balance value, it's lost. That's not how that works. Thank you so much. Are there any questions in the audience? If I may, I'm going to ask Markiyan. Markiyan, this question is very simple. It is understood that... Is Markiyan here with us? It is understood that the entire country has suffered. Like Bernard said, every victim has a name. Every business has a name. So what is the state's understanding of this? Will there be enough justice for everyone? There has to be enough justice for everyone, otherwise it is not justice. It is selectionism. Conceptual, fundamental principle that we are following is that everybody who has suffered damages can claim for compensation. People, businesses, and the state in general. So 3 significant categories of possible claimants. There are only 3 criteria that, as of today, have been properly documented. The first is territorial criteria, so the damages have to have been suffered on the territory of Ukraine. The second is the time frame criteria, since February 24th, or maybe earlier, since 2014. And the third is the connection between the damages suffered and Russian aggression. So anyone who has suffered damages can make a claim. If there won't be enough arrested assets for everybody to receive a compensation, where else can we receive the funding? What do we do with the people who failed to make a claim in time to receive the compensation from that 400 billion? Or I'm going to turn on my lawyer, put my lawyer pants on. When we run out of the 300 billion, we'll still have claimants left, it will be a good problem to have, because it will mean that we have spent 300 billion on compensations. We'll settle this issue when we get there. Our main goal right now is to either receive access to that money or to have the global community help us convince Russia to participate in this compensation mechanism, whether willingly or through the percentage from the gas and oil export income. It might sound unrealistic right now, but look, so many things have happened in 9 months, so many stances and ideas have changed, that nothing is unbelievable, nothing is impossible. And in case Russia completely refuses to pay compensation, we're working on a mechanism to actually arrest assets. But everyone who suffered damage has to be compensated. That was actually my next question. How do you evaluate? I know that it's not a legal question in essence. It's more a question to Natalia in terms of science and statistics, but how high do you think the probability is that Russia, the Russian Federation, will at least partially agree to compensate these damages? Or is this scenario completely impossible? Is it being discussed in any way with someone? The answer is very simple. The Russia will either agree or refuse. It's 50-50. We will not think for them. We have to take care of the problems we have right now. A very important message that we are spreading amongst our colleagues is that their responsibility to pay reparations does not depend on the country's willingness. Doesn't matter whether Russia wants it or not, we will move in this direction. This is actually what I wanted to hear. It doesn't really matter whether they agree. They will definitely have to pay. All right, we'll have a question from the audience, and then I'll make my closing remarks. Could you please introduce yourself? Bernard-Henri Levy, наш формат. In the history of the wars, there were precedents where the winning side temporarily loaned a part of the territories of the losing side. For example, the Soviet Union took Königsberg. It's been 50 years and they're not returning it. Great Britain took Hong Kong for 100 years. Are we considering, once again, we don't really know what Russian Federation will look like after a victory. Are we considering loaning Russian territory rich in oil and gas as a compensation? Who are you addressing your question to the state representative? Mr. Markiyan, please. That's a great question, actually. But we are not Russia. We are not invaders. We don't need other countries' land. Unlike Russia, we respect international borders, internationally recognized borders, and everything that Ukraine wants is to restore our own territorial integrity, our sovereignty, our independence. It's not my task to comment on what Russia will look like after the end of the war, and it will not be our problem anymore. Our task after the end of the war is to rebuild our country within our borders, internationally recognized in 1991, that the Ukrainian population voted for in 1991. Thank you so much. If there are no more questions from the audience, I would like to thank our speakers. The only thing is I would like to ask for all of you to say a few words, like 15 seconds, closing remarks. Bernard, if you're here, we're going to start with you. A closing remark. We cannot hear you. Oh, no.
Yes.
Can you hear me?
Yeah. Just a couple of words for like closing remarks.
Just one word. First of all, I would like to quote a very important philosopher of the 20th century, Emmanuel Levinas. Emmanuel Levinas was a French Jewish philosopher from Lithuanian origin, and he used to say that there is an ethical role of money, that money is not just money, that money is not a dirty thing, but that money has a role in the social relationship, an ethical role. And Levinas said, either you have barbarity, the world considered as a prey which you can catch, or you have this tool of reparation, of compensation, and of justice, which is money. And I say that because I was happy to see today lawyers, administrators, people of the state, philosophers being on the same page, considering that Russia has an infinite debt to pay to Ukraine, and that the international community should have a role of referee in order to implement this debt and to compel the one who contracted the debt, which is Russia, to realize it and to pay it.
Thank you.
Philosophically, it's fair, it's correct, and it is just.
Thank you very much. Andres.
Confiscation of the central bank reserves of Russia the top priority in its discussions with the Western powers. Thank you.
Thank you very much. Markiyan.
Markiyan? In September in New York, Irina Mudra and I visited a meeting of the foreign ministers of countries that are dealing with MH17. So it was Netherlands, Australia, Ukraine, and Canada. And I expressed a thought. I said that there was this parallel between MH17 and the case of reparations. The case of MH17 shows us that justice takes a long time. It is very complicated, but it is inevitable. It is symbolic that we are talking about it right now, when in Hague, the court gave a life sentence to the 3 perpetrators of the horrific crime 8 years after the crime was committed. It's the same in our reparation case. We have to be patient. It will take a while. It will take a lot of work. But the justice is on our side, and it is inevitable. That's why we will succeed and rebuild our country. Thank you. Timur? Honestly, it's very difficult to add something, but I would like for all of you to remember that every claim, every court case is an additional instrument of pressure on the aggressor. And it is something we should always keep in mind. So please, even if it doesn't look like it will be a successful case, Markiyan said something. There was a very important ruling taken today, and I'm convinced that the world is changing, and I'm convinced that we will see effective changes in this area. So if you're making a claim, you're not only benefiting your business, you're also helping the state and helping the world to pressure Russia. So go ahead, choose your avenue, choose your instrument, and make a claim. Thank you. Natalia? I offer all of us have a goal of achieving compensations in a few years, maybe $2 or $10, but we have to be compensated in a few years. We have to demand this, and we have to not listen to people from the UN saying, well, wait another 20 years. No. Let's demand for justice to happen faster. Svitlana, I'm gonna get up because I'm not gonna use my words. I have a famous poem by Ivan Franko called Stonemasons. I'm not going to read the entire poem. I'm just going to read a part of it. Please listen. Everyone in our hands has a heavy hammer in our hands, and the voice from above tells us, destroy this rock, do not let weather stop you. Bear everything, because it is your destiny to destroy this rock. And we all raised our hands and we started hitting the stone, and the stone started falling aside. And together we kept hitting the stone like a waterfall, like a battle. Our hammers were hitting the stone, and we were fighting for our place. Even though the rock destroyed a lot of us, we kept persevering. Nothing stopped us, because every one of us knew people will forget us. They will never remember what we had done. But people will only move through this road when we destroy the rock that is an obstacle. And they will only walk here when our bones shatter under the rock. We didn't want any glory, because we're not heroes. We are slaves that accepted this burden of freedom. We are just stonemasons. The victory is ours. I don't really have anything to add. I'm really happy to have all of you here today, because every discussion like this is yet another impetus, is yet another input into justice working. I would like to thank each and every one of you for doing something today, for thinking that there's something that has to be done, for considering making claims. And I would like to thank all of you that haven't done anything, because you are our potential. First of all, you're not preventing us from doing anything, but also you are the potential. Thank you so much for being here, because only by coming together, the state, the business sector, the education and science organizations, only by coming together, we will make Russia pay. Thank you so much.